I'm Jonathan Handel. I've been involved primarily in a Hollywood guild world, as I like to call it, for about 20 years. Actually, longer ago than that, about 35 years ago, I was on the legal staff at the Writers Guild, representing screenwriters and television writers in disagreements with management. Starting about 20 years ago, I started blogging on the subject of what became the writer's strike of 2007 and '08, and then the Screen Actors Guild, SAG, stalemate of 2008, 2009. That led me to a position at the Hollywood Reporter for 10 years as their guild reporter, concurrent with my law practice, which evolved from strictly transactional work to also including labor-related work on behalf of members, on behalf of unions. I was outside special counsel to SAG-AFTRA for several years, and on behalf of producers as well, management side. There's something to be said for each of these sides. Labor law, the history of labor law in this country is tied up very intimately with the political history of the United States. In the 1800s, after the Civil War, the Industrial Revolution developed. Think about railroads, think about oil drilling, think about mechanization, steam shovels, the development of electricity, light bulbs, Edison, all this sort of stuff. And that created a centralization of power, a centralization of corporate efforts that left many workers in the dark, ironically, out fighting for themselves. They started to come together, to fight together, and management fought back, both in the United States and the United Kingdom, both sides of the Atlantic, first using conspiracy law. You're conspiring to deprive the merchant or the company of the services that he or she is entitled to. Usually he, of course, is entitled to. You're conspiring to interfere with freedom of commerce, those kinds of things. This Sherman Antitrust Act made that even more formal. This was largely an act whose focus was to begin to rein in the power of some of the so-called trusts. In other words, some of the large companies, the oil, banking, railroad fortunes that were the Gilded Age of the time. But they included a provision, or the act, I should say, included a provision that said that two or more people cannot conspire together to set prices, to determine market conditions, to act together and to collude. And that was applied against workers as well, frequently violently, frequently using local police, using private police, muscle forces, the Pinkertons and others, to break up and physically harm people engaged in unionization activity. So what changed? How did we get to where we are today, and where are we today? What changed was the 1920s were a time of the so-called roaring 20s. Capital, the wealthy were doing great. Everything was humming along. What was good for business was good for America, all that kind of thing. And then came Black Friday, the stock market crash that triggered the Great Depression. And you end up with a liberal president elected, FDR, several years later, 1932. He said, "I see a third of a nation ill-housed, ill-clad, and ill-fed." It was that desperate a time. And political attitudes changed. People were not willing to simply say, well, management can do whatever it wants and who the hell cares what goes on with labor. People were not willing to say it's all antitrust, it's all freedom of contract. If the baker didn't want to work 20 hours a day, he wouldn't have contracted with his boss to work 20 hours a day. Freedom of contract. We started to see protective laws. The Supreme Court reversed some of them, and Roosevelt threatened to expand the court. And in the switching time that saved nine, as they call it, the Supreme Court started upholding worker-oriented laws. And one of the most important of those laws was the National Labor Relations Act. The National Labor Relations Act allows employees, not independent contractors, and it's a very important distinction to think about in today's economy, where you have so many different people who are independent contractors, whether they're website designers, graphic designers, Uber and Lyft drivers, et cetera, But employees can take concerted action. That is, they can act together to discuss and work towards better wages and working conditions, and to work towards unionization and to form unions. to join unions. Now, the National Labor Relations Act, as it reads today, also provides protections for workers from unions. They don't have to join a union, things of this sort. How did that happen? Well, the 1930s, the Great Depression, the era where people were more oriented towards the little guy, as it were, and increasingly the little woman in the economy, the outside the home economy of the nation, came to something of an end with the U.S. entry into World War II. The economy was put on a war footing. Obviously, lots of things changed. And you'll remember that when the World War II ended, the Soviet Union, which had been a partner with the Allies against Nazi Germany, became adversarial towards the Allies. We have Churchill giving a speech that an iron curtain has descended on Europe. We have the search for communists. And in labor law, where there were in the 30s many avowed communists who were involved in organized labor, what we saw was a dialing back in the 50s and in the early 60s of labor rights. So we have the right, we have unionization rights, but those rights are made difficult to exercise, and in certain ways, a lot of details about unionization that can make things difficult. And obviously here in the USC context, we're seeing USC fighting back, using every tool that it has under the law to dissuade people and ultimately to dissuade courts and decision makers, National Labor Relations Board, from allowing adjuncts and part-time faculty to unionize. That really is a product of the conservatism that we saw develop in the 1950s post-war, the late 40s, the 1950s, the early 1960s. The peak of private sector unionization in this country was really about 1960. And from then on, there had been a somewhat slow decline that was accelerated in 1980 when Ronald Reagan, who ironically had been president of the Screen Actors Guild, which is of course a union in Hollywood, became president of the United States. He broke the air traffic controllers union, fired all the air traffic controllers who were on strike in 1980 or so, and that accelerated an era for a good 30 years or more of antipathy towards unionization. Starting in the mid-teens of the 2000s, around 2015, 2012 or so, really post the Great Recession that happened in 2008 for a couple of years, there's been some swinging of the pendulum back. Unionization prior to that seemed like something that was for older people. You know, if you're in the later stages in your career and you're working for a legacy sort of company, but you know, startups and digital companies aren't like that. Well, in New York in particular, in New York City, the Writers Guild East and the News Guild, which was the old newspaper guild, have had great success in unionizing digital media shops. So the same 20-something who's covered with tats and who drinks coffee at a cafe is quite possibly a union member. So where we are now, we also have developed, and particularly post-COVID, a great deal, but starting prior to COVID, a great deal of independent contractorhood in the economy. A lot of people are independent contractors rather than employees. They don't have the same rights that employees do. They don't have rights under the National Labor Relations Act. Independent contractors can't gather together and form a union or declare we will not work for less than X dollars per hour, whereas an employee can do that. That sometimes even helps management. In Hollywood, for example, rather than having to negotiate with every single actor who's acting on your movie for a day, so-called day player, there's a rate in the union agreement. It's around $1,200 or $1,500 a day at this point. I don't know the exact figure right off the top of my head, but it means that management doesn't have to negotiate every single little transaction. You're a day player, you're signed, here's the role you're going to be playing, here's your script, here's the day we're going to be shooting, and you'll get the standard day rate plus 10% for your agent. Contrast that with Silicon Valley. At one point, two of the major Silicon Valley companies, I believe Facebook and Google, don't hold me to that, agreed that they would pay junior programmers no more than 175,000 a year or some figure. They tried to set prices and agreed to not poach programmers from each other. They got hit with fines for that. That was a violation of antitrust law. The difference here is that even though in both cases we're talking about employees, and in Hollywood even the day player is an employee, there's no collective bargaining in Silicon Valley, or there wasn't. There is some now, not a lot. There is some, but those programmers were not covered by a labor agreement. The companies weren't jointly bargaining the way studios jointly bargain with the actors, with the writers, and the directors in Hollywood. So what you can see from this is a situation that is very complex and very political, and unions, with a few exceptions, particularly police unions, generally favor Democrats. Democrats generally favor unions, Republicans the opposite, and there is the risk that this case, if it goes to the Supreme Court, will be used as a vehicle to further undermine union power in the United States.